Hi, everyone. Welcome to another episode of the Ask Amity Show. Today, we'd like to talk to you about whether or not a trust amendment is necessary or a restatement of a living trust and what is the difference. So a trust amendment is a legal document that changes specific provisions of a revocable living trust, but leaves all of the other provisions unchanged. While a restatement of a trust, which is also known as a complete restatement or an amendment and complete restatement, completely replaces and supersedes all of the provisions of the original revocable living trust.
Well, there really aren't any established rules as to when a restatement is required, but generally speaking, if the changes are minimal, such as number one, adding or deleting specific bequests, number two, changing who will serve as a successor trustee, or number three, updating a beneficiary or the successor trustee's legal name due to marriage or divorce, then a simple trust amendment will likely suffice.
And a complete restatement should be considered, on the other hand, if the changes that the trust maker wants to carry out are more significant, such as adding a new spouse as a beneficiary, completely cutting out a beneficiary, or changing from distributions to family members to distributions to a charity, or vice versa.
Additionally, if you've made a series of 3 or 4 simple trust amendments over the years and you now want to make an additional change, consider consolidating all of your changes into a complete restatement. This will be really helpful to your successor trustee so that they would just have a single document to follow instead of trying to piece together the provisions of 4 to 5 separate documents. So that's all that we have for you today. If you have any questions about amendments or restatements to your revocable living trust, give us a call. We'll be more than happy to speak to you. We do provide free consultations. Thank you for watching and remember to subscribe.